All right, so I'm here with our awesome Master Jedi broker, Mr. Murray Coleman, and we are going to go through the 18 ways real estate agents can get into trouble.
Exactly. So 18 ways is a very
fluid
number. It started off back in about 2009. I think I first started realizing that there's a common thread where there's definitely, you can definitely identify when an agent's going to get themselves into trouble.
All right. What's number one?
Number one, well, they're not in any particular order.
Okay.
So I want to start with number two, because that one is like the real common thread with everything, and that is the communication skills. It's making sure that from the moment the transaction starts or the relationship starts, so as we know, everything is relationship based in this business, and establishing a good working relationship initially with the customer is key. Two reasons. One, it gives them an idea of where they're going to go and what's going to happen on the transaction. And secondly, it establishes your professionalism. So I think we tend to be in so much of a hurry to get to the closing table that we forget the steps on the way. And by building that relationship at the beginning and explaining to the customer this is what's going to happen, and remaining professional throughout the transaction. You can have the social side of it. There's nothing wrong with having some fun with the customer, but business is business. And by keeping in emails, in phone calls and text, you have your business calls and then you have your fun calls, and don't mix the two. A lot of times we get subpoenaed for documents for court cases, and we're not most probably involved in the court case, but I have to go through people's emails and their documents, and I find that sometimes it can be embarrassing of what's in an email that should have been a business email, and it's mixed in with some other
with fun.
So if you can get if an agent can get communication right and establish a process, a transaction-based process, that we're a very fact-driven. I use the expression all the time that in the absence of knowledge, emotion fills the gaps.
Say it again.
In the absence of knowledge, emotion fills the gaps. So if you know what you're doing, and then there's absolutely no need for anyone to ever get emotional. So communication, keep the emotional language out of it, keep the rhetoric out of it, just fact. We want an extension to the inspection period. The answer is going to be yes or no.
Or no.
Yeah.
Correct. So no emotions.
No, not in
Keep
there.
them in between the lines.
Exactly. And then we go back to number one on the list, which is missing critical dates. I read a blog this weekend actually from a law firm in Sarasota that sends out a weekly blog on legal matters. And one of the things that they said was, in light of a recent court case, that the buyer and seller and the agent have a joint responsibility to watch the dates. It's not just the agent's job to watch the dates. But what helps is to calendarize everything before you start the transaction. As part of that communication bit, it shows you're a professional. It shows you know what you're talking about, and you say, here's what's going to happen. We're executed on this date, which means your escrow needs to be with the title company at such and such date, and then
inspection period will be
and just calendarize all those dates, and then get some kind of agreement from the other side. Just say, we've provided this to our customer. Do you have any comments on the dates that we've provided? And if they come back and say, well, we don't agree that we were executed on this date, then sometimes agents will get into a fight over something which really isn't worth fighting about. If the other side thinks you were executed on such and such a day, if it really doesn't matter, it's okay to not be right. You can just say, okay, but we'll call this then, and we can call it the effective date. And as long as everyone's working off the same timeline, we're good. So, missing critical dates. The biggest one they miss is the loan approval. And we talked about that earlier, that paragraph 8 of the contract it measures, sort of 5 inches, but there's a lifetime of words in there.
Yes, it's a lot
Yeah.
in there.
So, we have that loan approval period, and if they fail to send those notifications at the end of the loan approval period, it puts the seller in a position of power, and it puts the buyer in a position of weakness.
Correct.
And so that's one of the most important days in the contract, to make sure that doesn't go by without sending the notification.
That line 120 makes me so nervous all the time.
It should do. It should do. When just going back to communication, one of the things I always advise people to do is always write in the third person. So, there's no I in this. I smacked my microphone.
That's fine.
I do that all the time, and you hear the boom. There's no I. It's the buyer has said. The buyer requests. The seller requests. It's not me. I want an extension. No, you don't. Your buyer has requested an extension.
And I think that's such an important point, because sometimes agents can cross the line of making decisions for their clients, right? And it's, like, I'm always in having some type of conversation with an agent where I'm like, not your choice, not your decision. Stop making stories in your head. Talk to your client. Is that what the client wants to do?
Yeah. And a lot of times when people text me and say, how do I deal with this situation? There's no real situation to deal with. You have options that you present to your customer, and then you transmit that back to the other side by saying, there's, for instance, the closing date is either going to happen or it's not. So if the buyer needs an extension of the closing date, we're going to ask for an extension. We ask for an extension of the closing date, give a reason, and the answer can be yes or no. Yeah. And then if it's no, then if we have a good enough reason for it to be automatically extended, then just factually go back and say, well, the contract provides for us to have this extension. As long as everyone's in agreement, we'll move forward. And if they're not, then we go back to the buyer and say they've disagreed, which is a legal problem. You're advised to speak to an attorney. What would you like me to do now? It's not our decision.
Correct.
Good.
What else?
Post-closing defects.
That one makes me so nervous.
We want to help. We always want to help our customer. We've spent all this time with them as either the listing agent or the buyer's agent, and then things that go wrong after closing.
The septic decided to overflow.
Constantly.
2 days after closing.
So I always
and now they're calling me, the agent, so that I can solve this problem. What do I do, Murray?
You just have to say to them, every bone in my body wants to help you. But our relationship as a customer and agent ended at the closing table. Everything that I do for you now is likely to be an unlicensed legal practice, because I can't represent you. And that would be a felony. And if there is a problem with, let's say, the septic, if the septic does overflow, we'll say, well, let me get all the paperwork that we had, let's have a look back at the inspections, let's see the seller's real property disclosure, but here is what you need to do, Mr. Buyer. Obviously this wasn't disclosed. If you believe it was a defect that wasn't disclosed, then the only way that you can address this is by speaking to an attorney, or you can write to the seller yourself. But I advise you to speak to an attorney. And you just have to say to them, I want to help you. That's what my
But I want to help them, Murray. I want to help them I want to give them a solution, because that's part of the reason why they hired me in the first place.
You will mess up their case, because the attorney that gets hold of it eventually will spend more time, most probably, going after you for practicing law than they will for getting the septic sorted out. So I'm not saying every attorney is going to do that, but I've seen attorneys go that route.
Especially in our environment where attorneys want to get real estate agents.
Where I've seen agents come really unstuck is with builders. So a builder provides a warranty, and the agent gets a phone call from their new construction buyer that says, hey, we've been here 3 days and I can smell something in the house, or something's wrong. I've tried to contact the builder and they're refusing to talk to me about it. And they said that they'll send someone round, and they haven't, and blah, 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 blah. They've got big attorneys with builders. If you start putting yourself in the buyer's position and start writing to the builder on their behalf, you will find your career will end very quickly, because they will come with all guns blazing. Yeah. So I think we slogged that one.
Yeah.
Post-closing defects.
all you can do is send them a bottle of wine so they can.
Yeah, and just say to them, hey, I want to help you. And sometimes agents have said, well, look, I've got someone that I know that can fix this for you. And, I've had agents send their husband round to fix some small problems, which is fine.
Yeah.
But just be careful that you don't get yourself in too deep. Talking of getting in too deep, my next one is a very short one. Is paragraph 20, or the additional terms in any contract.
I know that you love it when we pretend to be lawyers and write all the things that sometimes make the contract redundant, or we're duplicating stuff.
Right, it is a lot of
create,
duplication. Yeah, so the simple
confusion.
answer is paragraph 20 on the purchase contract, and then any contract. The only one I've got a little bit of leeway with is the listing agreement. Sometimes you can write in the listing agreement, if Mrs. Smith buys the property, I won't claim commission. Something like that. And if you're going to write something, I'm happy to review it and make sure it's not going to kill you. Purchase contract, there is never a good time to put anything in there. You can maybe even, some lawyers have even said, just ask him for closing costs. It should be attorney written, because obviously they want it to be attorney written. But I think we've got some flexibility in writing a fact that the seller will provide X% towards the closing costs for the buyer. As soon as you go off plot and start writing anything at all in an addendum or paragraph 20, you put yourself at risk. Because you then assume the responsibility for that authorship, and we're not lawyers to be able to do that. So we have certain things we can write, and the one that we write the most are repairs requests. And there is a spectrum of an excellent repair request down to ones that just really put your customer in a bad position. I spoke to an agent this morning, and they had some kind of dryer vent that was going to be installed in the attic, and they're at the final walkthrough, and the dryer vent was not fitted to the buyer's satisfaction. And the first thing I'm going to ask for is, can I see the addendum to write that you had? And it says, simply, there's a dryer vent will be installed in the attic. It didn't say who by, what standard.
To whose satisfaction?
Everything, and it's very difficult to write. Anyone will tell you one of the most difficult things to do is to write a piece of legal prose that covers every eventuality. But the tip is, if you're going to write it, is to use all the W's and an H, is the why, when, and the how, and what proof is going to happen at the end of it to prove that it was done. So even a simple thing like a dry event should say a XYZ dry event will be fitted to the roof space by a licensed professional. There'll be a receipt, there'll be a warranty, whatever it is, and it'll be done by the final walkthrough. And as long as we're clear, if it isn't, you can't hold up the addendum and say you didn't do what this said if this doesn't say anything. Because I use an example. Someone put in an addendum, the air conditioning unit will be replaced prior to closing. Well, that was all it said. So my question was, could it be replaced by a bucket? Could it be replaced by a daffodil or a sandwich?
Yeah, we put in another air conditioning unit.
And what happened in this one was they actually put another air conditioning unit in there, but it wasn't a new one, and it was it wasn't exactly what the buyer wanted. So that's why.
So be specific.
Be specific, because it's embarrassing for you as a buyer's agent when you do the final walkthrough and you realise you haven't protected your buyer enough by those words.
Absolutely. So are you seeing now with the, with AI and ChatGPT and all that, are you seeing more agents writing stuff on additional terms that, no one should be ChatGPTing?
Yeah, well, ChatGPT is wrong more than it's right, because we're 50 states and we have different laws in different states. We have different laws in different municipalities within the states. So it's very difficult for you to have any 100% reliance on anything you write, and ChatGPT isn't your lawyer. And the only way you can be sure is for the parties to have their own lawyer write complicated stuff. If you do use ChatGPT, And I haven't seen a great deal of it because the compliance people will send me anyone who's got, anyone who's gone all out, Robert Ludlum, or author, in there. They send me. I have if it's more than half an inch, then I really need to see it, because there shouldn't be all this stuff written in there. But no, I haven't seen too much. But I know the temptation's there.
Yeah.
And we use different. There's legal AI that you can use, and I've used some of that stuff, and we have. Lawyers have access to some stuff which is easy to do, but you are still the author, and unless you're a lawyer that's engaged by that particular customer that becomes their client, they can't act on their behalf. So I see agents say, well, I got this from a lawyer. Well, did you get it from the buyer's lawyer? No, it was a lawyer.
Not any lawyer. Not your friend that who
just came in and said, oh yeah, here's some stuff. There's approved, but there's a copyright on that, so you can't just say, oh, I had a post-closing, what's it called, a pre-occupancy agreement.
Oh, those are your favorite too.
Well, that comes up in there. But I had a pre-occupancy drawn up for a customer, and I used that. No, you can't do that.
Yeah.
All right. Number 6 was, actually number 5, we missed number 5. An easy one, and every agent that's taken the real estate exam will know that you failing to disclose known defects.
Absolutely. When in doubt, disclose.
Georgia Alpazar, my favourite original director.
That woman.
I will call her back later. Let's just give her a little thing. You're going to have to do some editing here.
That's fine. Or not, they can laugh at this.
Where were we? Oh yeah.
Number 5.
Number 5. Failing to disclose defects. The whole, an agent will call me and say, "Hey, this was in the house. Do I disclose it?" My answer is yes. If whatever it is, if you've asked me, should we disclose it? The answer is going to be yes. And if the customer doesn't want to disclose it, then we're going to disclose it. If it's a defect that will affect the value, and it's not easily discoverable. If the seller says to you, we had a leak in a pool a few years ago. This is a common one, it's leaky pools. And you don't get them in Wisconsin or New York so much, but Florida, everyone seems to have a pool. I had a leak in my pool 3 years ago. Do I need to disclose it? Yes. And the play it forward on those is, I always say, if you were the buyer and you found out that there was a leak in this pool, when you bought it, it was disappearing water, and you went to the pool equipment and saw a pool company and you called them to come out to fix your leak, and they said, oh, we've been out there before a few years ago. That's when the sticker got put on there. And they say, oh, were you? That would be a problem.
Yeah.
That would be a problem.
Could that be a problem legally between the buyer and the seller?
Very much so. And it's our biggest cause of lawsuits is defects. And even if the buyer and seller get into it, even though we may not have known about the defect, the seller might not have brought it up to us. We get roped into the lawsuit because they want to find out what we did know. And as soon as you get roped into the lawsuit, then it's costing you money to defend your position you shouldn't have to defend anyway because you didn't know anything. But we get called into these where there's like a crack in the sea. One I'm just dealing with at the moment, there's a crack in the sea wall that was discovered after the person bought the property. And we had no idea. There was nothing to say there was a crack there. The seller didn't tell us, didn't put it in the disclosure. But a year later, the new buyer finds out that there was a crack in the seawall and there was losing land underneath. And when they called the land people out to take a look at it, they said, oh, we've been out here before. And then our agent then gets pulled into the lawsuit. And all they're going to do is spend their deductible having to just go to court saying, I knew nothing.
Yeah.
And it's sad.
Yeah, that's a lot of money to say, I know nothing.
I know nothing. Verbal versus written. Any agreement between parties must be in writing and signed. Because it says there's a a washing machine conveys in the MLS.
Doesn't
if it's
mean
not in the contract, then it doesn't exist. Yeah, and people always say, well, it said in the MLS the washing machine was staying. You can say in the MLS that you
doesn't matter. What matters is a contract.
Yeah, anything. It's just fluff. It's advertising fluff. And until we've got it in contract, then that's it. Even if it's in an email, So if they said something like the the washing machine will convey in an email, it's still not enough because it's not a contractual term.
Correct.
Yeah, good.
Very good. Number 7.
What I want to leave number 7 is to read this. It's a very in the handout because it's what stays and what goes. Personal property. We don't sell personal property.
So we're not rooms to go.
We're not rooms to go. We do not sell furniture, we don't sell washers and dryers, we don't do anything. We have a little bit of a leeway because they give us a line in the contract that gives you a space to put washer, dryer and other things, dartboard in games room. That's fine. If it's more than that line, and just
if we're selling a furnished Airbnb, how do we do this?
You look at further on in the contract, in the standards, all those words in the last pages, there's a little section there called conveyance, and it says there, personal property must not be included in this contract. It must be conveyed by a bill of sale. And so what you say is, okay guys, you want to buy this house, it's fully furnished, here's a blank piece of paper, write
blank,
down
not an addendum.
Not an addendum. Write
Blank.
down whatever it is you want, and Mr. Buyer, whatever it is you want to see here on closing, and Mr. Seller, you sign it to agree it's going to be here on closing. We don't even assist them in the process. It's not our job. We don't sell personal property. And they both sign it. They make it contingent upon the real estate selling, because you don't want them showing up on closing day when the house falls through and say, hey, well, I've got a bill of sale here for all your contents. Yeah. So, and that's happened. Yeah, that's why I mentioned it.
I couldn't do your job.
And so we get to the point where we're not arguing on closing day about a table tennis table in the garage like we have in Kissimmee. You know, we have these rental properties. I've had people arguing about table tennis table, bats and balls and stupid stuff. If it's not, you shouldn't put, for goodness sake, never put the entire contents of the property.
Yeah,
or
never.
The other one I like is as seen on MLS. I mean, it makes no sense whatsoever to me because we don't know what's on there.
And they can change pictures on MLS,
Exactly,
so come on.
Exactly. So I've done a very nice, on the handout, I've done a very nice checklist for people.
And we'll attach the handout to the email, guys, so
good.
It's there.
There's a great little, I think it's great because I wrote it.
It is great, I'm looking at it.
It just tells you, if you're on a listing appointment, go walk the house with the people, show your value and say, what's staying and what's going. One agent I know, she carries a little pink post-it notes, and she walks around and says, is this garage shelving staying? And they say, yes. And they put a yes on it and then someone comes round afterwards, one of her assistant people comes around afterwards and gets all the sticky notes, takes them back, and then they write up the what's staying and what's going list.
Love the system.
Yeah, works great.
System.
System's good. Anyway. Number 8, we've already really covered, was poorly written addenda. Just be very, very careful.
So if they need to write an addenda for whatever it is, if they're confused or they're not sure what to write, where should they go?
Well, I am happy to read them, and it's best way to do that is to email me and just say, hey, I need to put this into writing. Send it to me in an email. I just love to text, I know that, but I'm getting old and it's easier for me to look at it on the computer. Yeah, I can forward it to my email, but I like to see the document there, and if it's editable, that's even better, because if they send it to me in the body of an email, I can edit it if necessary, and I am not their attorney either. So I'm bound by the same rules as they are, but I can make it more protective, hopefully. And then I may just look at it and go, you know what, we're not going to touch this. This is too crucial. They need their own attorney to write this.
Okay.
Or we need to look at this from a different angle.
Very
good. Closing missteps. Closing day is my busiest day. So Friday is a day where I just kind of hunker down and wait. And it normally starts
Wait
Thursday
for
night.
the storm.
Wait for the storm. And especially at the end of the month. And don't get me started on the end of the year, because this year was crazy. Everyone was trying to close before.
How many agents are you brokering now?
Well, I oversee the transactions for about 2,500. So we cover.
That's a lot.
With help. You know,
Yeah. Yeah, of course.
I have partners in every office, but solely we're looking at an average of about 200 to 300 transactions a week that close. So, which equates to about, I think it was last time I looked, it was about 5 billion a year in sales. So there's a lot.
Yeah.
And we've managed over the years with Sally and I to identify these sort of pain points. And when I first started, I had 3 offices, and I had more calls from those 3 offices than I do now. I look back at my call logs, and I used to get more calls because I hadn't identified yet the pain points. So when I get calls now, they're normally big stuff, like there's a seller complaint, or another agent complaint, or something that's not that's really sturdy. You can tell my phone just goes off all the time. But.
Of course,
and I should turn it off, but I need to know, because what happens if I don't hear it, then I'll go out here and I'll forget.
Yeah.
But I'd have to give $20 to KW Cares for every time. I'd be penniless. The closing day, final walkthroughs. It starts Thursday night normally, and you get to the final walkthrough. And these are things that should have been prepared for earlier. So make sure you plan, if you're the buyer's agent, make sure you plan the final walkthrough for closing day or the day before. The day before is a lot better if you can do that.
Gives you a little bit more time.
Yeah. If the main thing you're doing at the final walkthrough is really looking at paragraph 6A of the contract and making sure all personal property's out, make sure all the repairs have been done that you have addenda for.
That it's been broom swept and the garbage is out.
Yeah, well, it doesn't,
I love the details of it.
So you show your age then. Broom swept has not been in a contract for about 22 years. Yeah. But people still use it.
I know.
Broom swept, it doesn't have to be clean.
Correct.
And so there's an opportunity then to show your value with a buyer, is to say, you know what, the seller has not got any, all they have to do is get the trash to the curb. So why don't we, in a buyer's market, say to the seller, we want the property professionally cleaned with receipts and everything. In
the best practice should be.
You could ask them that if that's important to you.
Absolutely.
If it's important to you that X, Y, Z, let's get this ahead of time. Let's in the inspection period, let's look towards the final walkthrough, because you don't want to get there and have the seller walk through the door because they've driven by the house a few times. They're looking forward to it. They got all their little kids, and the first day.
This is what we call bulletproof in the transaction.
Yeah,
and all the things.
Scrubbing the floors and cleaning the toilets. They don't want to be doing that. Yeah. So I think you can show your value. You're right.
Absolutely.
Don't do the walkthrough before the furniture's been removed.
Tell me about that one, especially when area rugs are involved, and then the area rug comes out, and all of a sudden, there's an issue on the floor.
It amazes me that we get to closing, and the final walkthrough, they take a sofa away from the wall, and there's missing drywall. So why didn't the inspector see it? If you're at the inspection, talk to the inspector and look for things at the inspection instead of just, being there. You can be fairly useful by just saying to the buyer, if you are at the inspection, just say to the buyer, let's make sure there's nothing in here that could be hidden that we're not going to find out. And if there is an area rug, just peel it up a little bit.
Yeah.
There's only a certain amount you can do. But what you don't want to happen is, when they're taking the sofa out and they graze the wall, or they smash the door frame, or whatever, they break a window. All these things are a problem if you do the walkthrough without the furniture, while the furniture's still there.
What about if I go into the walkthrough alone without my buyer?
The final walkthrough, no. I mean, it's the buyer's final walkthrough. There are times emergencies happen, and they can't do that. We've had situations where the buyer's been in an accident and couldn't get to the walkthrough, and I did one personally for a buyer that was in an accident, and I literally went to the walkthrough. It just happened to be near to my home, so you can take an iPad, I have a form that I created with Sally to use if this emergency comes up. That says I will walk through the house with a camera. I'm not going to say a word. I'm going to show you everything, and you're going to sign this form to say I was unable to do a walkthrough, release Keller Williams, but they kindly let me see. The best practice would be to call the inspector that did the inspection, have them do the walkthrough. Call an aunt, call someone, get someone else there.
Someone on your side.
Other than us.
Yeah.
Other than us.
Good.
All right. We're getting slowly towards the end here, so we're getting to the quick ones. On a standard contract, if you use a standard contract, you must do the HOA rules and regulations and all that due diligence. The buyer should do that prior to going under contract. If they're using an as-is contract, then during the inspection period they should be doing a permit search and they should be doing an HOA search if it's important to them. Once you get out of the inspection period, if you find that there is a rule on the HOA about dogs, too many dogs, or trailers in their property, whatever it is that might affect the buyer, there's no real get out of jail there, so they're stuck with it. So make sure they do it. And then permits, for some reason we tend to let the title company maybe will do a permit search, maybe they don't. And if permits are important, building permits are important to a buyer, have them do their permit search don't you do it for them, have them do it during the inspection period. Because if they do find out from the title company at the end of the transaction that they've some open or expired permits that the seller didn't know about, if the seller knew about them and didn't disclose it, we've got a different
it's a different story.
Yeah. But if the seller didn't know about it, and that happens all the time, I wouldn't know what open and expired permits are on my house. But my advice is for the listing agents, our listing agents should be talking to the seller about that. So do you have any open or expired permits? No, I don't know. Well, why don't we do a check? So we don't want this to come up as a problem later on. And then if you're the buyer's agent, you say, let's see if there's any open or expired permits before we go. Here's how to do it. You can go to this website, let the buyer do it. If it's a backward county that doesn't have online stuff, call them with the buyer on the phone and find out what's going on. Or
Very
visit
good.
them. Okay. Number 11, writing leases.
But we're not lawyers.
We're not. And
That's easy. You're not a lawyer. Don't write the lease.
don't write a lease. And what happens is we call them hidden leases. A lease is when you are giving someone else permission to use someone else's property. And it could be a car, it could be a lawnmower. You lease equipment for if you want to till your yard and one of those machines. You go to Home Depot and you sign a lease agreement for 2 days for that. And you'll see they're pages and pages long just to get that. There are things that we tend to write, and I look at it and I think, well, that's a lease. The buyer will store their car on the property the day before closing. That's a lease. You've created a lease, which is against the law, because only an attorney can create a lease. We're allowed to fill in the blanks on the Florida Realtor lease, but if there's any pre-occupancy or post-occupancy by a buyer or their property, or a seller or their property, then we need a proper pre-occupancy or post-occupancy lease drawn up. The riders that we have are just an intention to do that. So they're not the actual pre-occupancy or post-occupancy. It just means that we are going to do that, but it says in there that an attorney will write it up. Next, not knowing the advertising or team or group rules.
Do you mean to tell me that we don't understand that as agents?
We have a problem.
Because I think that should be number one.
We have a problem with measuring words.
Yeah, with measuring words.
Yeah.
That it has nothing to do with logo, that it has everything to do with fonts.
There's no such thing as a logo.
Exactly.
The word logo does not show
Exist.
at all in the regulation. So we have a rule which says if you're not going to use your own name, the name that's on your license to do advertising, and you're going to call yourself the Sunshine Team or whatever, then you cannot have that word bigger than the brokerage name.
It's a size issue.
It is. It's picky, and then the state are not out there to sort of trip us up. But believe it or not, some real estate groups or teams want to pretend that they're their own real estate company and look like they're a big deal, and it gets you into trouble. You know, I appreciate the reasoning. It's good marketing. You know, hey, you're working with the Sunshine team. You know, we've got this, and that. And that's great. But if you're part of a brokerage, then the law says, the state regulations say that the brokerage name has to be near the contact information. And if it's a team name, then the team name, wherever that appears, the brokerage name in the same size or larger than the team name must appear. And we have had agents, it's a $2,000 fine. And they'll hit you with $1,000 first. And then if they find other violations, like on your website, social media, you'll get another. And then if it gets too bad, you can lose your license. So it's a big deal.
And unfortunately, there's people out there on the MLS, like, on social media, looking for the missteps, looking for those agents that are not following the advertising rules, they're reporting them. So, you know,
it's other agents that report you. The state don't go out with the tape measure.
I mean, they should be lead generating in my world, but you know.
They should, but the state don't go out with the tape measure.
Yeah.
But if they get a report to them that
then they have to look into
then
it.
they look into it. And
Correct.
And the bigger agent, the more successful you are, the likely you're going to get.
The more you have a target on your back.
Yeah.
Absolutely.
13's easy. Don't use other people's photographs or descriptions. If you're writing a description, you've got AI to help you, but don't cut and
please
paste.
still edit that, because
that's bad.
I can tell when I am reading an AI description.
And then don't use other people's photographs without permission. If you didn't, my rule is if you didn't take it, write it, or buy it, then don't use it.
Love it. Simple enough.
Number 14, stop trying to be the escrow deposit umpire. So I feel like sometimes I need to get like a black and white shirt, because I get a call and they say, who gets the escrow, Murray? I'm like, I don't know. You know, whoever wants it.
Yeah, exactly.
Is the answer.
It's negotiable.
You know, if the seller thinks that the buyer is in default of the contract, then the seller can ask for the escrow. If the buyer thinks the seller's in default, the buyer asks for their escrow back. We don't decide. So I know that we want to add the value and say to the seller, look, you're entitled to the escrow. Most of the time, you're really telling them, hey, I'm setting you up for an escrow dispute here. So if the seller says, you know, can I take the escrow here? You can say, well, you look at the contract. It says that the closing date was Friday and today it's Monday and the buyer didn't close. You could decide that they're in default of the contract. You're advised to speak to an attorney.
Yep.
However, if you do cancel the contract now because the buyer didn't show up for closing, you could make a claim on the escrow. But let me warn you that if the buyer disagrees, then you're going to have to go through the escrow dispute process, which means that you're going to have to invest some time and money in pursuing this. Otherwise, the money is just going to go to the court and sit there for evermore. All right, we don't decide that.
Yeah.
We guide, but we don't decide.
I love that. We guide and we don't decide, and I'm constantly preaching that too.
This one's become more important lately, and these are not in any particular order, but it's a bad practice that we've got into because of computers. Hold on to the contract until you get all the documents before you present the offer to the seller. So if you get a contract through from an agent and says, I'll send you the riders tomorrow. Or
no, that's not a full contract.
Exactly. And legally, even though it says in the contract that, you know, this is accompanies with all the riders, if you as the agent present the contract to the seller without the riders and the seller signs it and sends it back, it becomes a very complex legal issue as to whether that was effective. Even though in the contract it says this is effective only when, that's not true. The courts look at the four corners of the contract. So even though it says that, but because seller has accepted this, signed it and delivered it, not knowing the full amount. So it becomes a legal argument, but the blame goes to the agents for not doing the job properly. So what the sellers should do is, the buyers and the agents should do, is, hey, hey, bud, I've sent you over a contract on your listing. That's great. I see you've checked off the lead-based paint, thank you. I see that's not attached. When can I get that? I'll try and get it to you tomorrow. Okay, I'll be happy to present this to the seller once I have everything. Okay, I am going to give them the contract and tell them to start reading it, but they won't respond. How can they respond?
Yeah, they don't have the full facts.
I don't know. There could be all kinds of nonsense in there, especially if with the one that's really odd that we found that we've been effective, and they've said, oh, we're going ahead to do the inspections. Well, they haven't even seen the FHA rider yet. They don't know what burden they're taking on.
Correct.
So just hold everything. It travels as one packet, backwards and forwards, and then there'll be no doubt. So I seem to keep getting issues where they're arguing about the effective date, and then we find out, well, this addendum wasn't with it, or this rider wasn't with it. I don't know where the term rider comes from. I've always just used rider, meaning it rides on the back of the contract. You can't set off on a journey without the rider on the contract. So it should travel as and when I find out it hasn't, it creates a grey area, and clarity is power, and we don't have clarity. Fair housing, I think one of the best pieces of legislation that's ever been written, and one of the most abused by agents. And fair housing is there for a reason, to make sure it's fair. And yes, at times I hear agents say, well, it's so picky, you can't say walk to the beach. And why can't you say walk to the beach? Because some people can't walk. Right. So it's one of the best pieces, I think, from a pure sort of social engineering perspective. It's a great piece of legislation, and it's something that we proudly uphold as realtors. And we accidentally breach it, but that's okay. We just learn. So the easiest test that you have is we deal with property, not people. The moment you start talking about the people that are going to be in that property,
towing that fair housing line.
Exactly. And I advise everyone to do the Fair Haven exercise with Realtor.com. It's fascinating. It's like a video game.
Yeah, I've
but
done
you can. I learned I went through it and I learned it, and it was just very interesting. But just test it. You read what you're writing, and say, am I talking about people or property? And if you take away anything to do with people, then you're going to be on the right side of regulations.
Yeah, we see this a lot in listing descriptions.
Yeah, we do, and Stella has creepy crawly AI things that go through and
like I cannot put white cabinets.
You can't put white cabinets.
It like irks me. I'm like, but they are white cabinets. I'm not talking about people.
Yeah, well, it gives you
white is not a bad word.
It gives you a warning, so you just ignore it and you can move forward. But it does make me laugh sometimes. Some of the things it picks up. 2 more to go. 2 quickies. Paperwork. All paperwork which has been signed by a buyer or seller has to be retained by the broker for 5 years. Where I'm running into problems is buyer-broker agreements. So
today?
If you work with a buyer and you have a buyer-broker agreement, that buyer-broker agreement's got to be uploaded into an opportunity, even though they don't buy a house. And I have to retain that for 5 years.
Okay.
We get into problems, and sometimes it comes in with a fair housing claim. I'll get a subpoena saying, this person worked as a buyer and they made offers on 6 properties, and none of these offers were accepted, and then they decided to just move on to another brokerage or gone. They want that BBA, and the agent may have done a BBA but never submitted it. So we've got to make sure everything they buyer or seller signs is retained for 5 years and put into an opportunity. So that's it.
That's the
simple. And then lastly, I've beaten this one to death over the years, but we still...
But beat it again, please.
Beat it again. Is if it's new construction, meaning it doesn't have a certificate of occupancy, the CO, then you cannot use Florida Realtors forms. So if you've got a small family builder, they're about so high, and if you think about it logically, in the court case that we're in at the moment, still in, it's been 4 years, the property was this high when we used an as-is contract. So the builders can say, well, it's in its as-is condition.
Yeah.
Even though I've added all this amount, if you're going to use the as-is contract, technically for him to comply, he's got to take it back down to that level, which is nonsense.
Yeah.
You know, it's just nonsense. It's ridiculous.
So what's the option?
The lawyer has to write a contract. They have to spend money. And the other option is to wait until it's got a certificate of occupancy and it becomes a residence and it's not a pile of bricks.
So if you are a small developer or you're working with a small developer and you're putting a buyer under contract, you should have the CO if you want to use a Florida farm.
Yes.
Otherwise, you need a lawyer to write the contract.
Exactly.
Very good.
And get it.
Understood.
And all I have to do is press a button in the law firm and they can shoot you out. And it's not an expensive thing. I think everyone thinks it's going to be expensive. And don't go on AI and get one because
AI is not a lawyer.
It's not a lawyer. and they miss things. You know, I tried to do one the other day just for fun. And they miss there's lots of laws regarding warranties. And that was not mentioned in this contract that Grok kicked out. So
there you go.
So
there you have it.
That's the 18 ways. I'm sure there's
plenty
of
more
other ways that you can try and find.
But these are the ones that you see the most. So these are the ones that we definitely want to get ahead of.
This started off. I think my wife asked me this morning. What was it? 13 was it? It was 13 for years, and then and I can't tell which ones I added because I mixed them up. But I recently added the new construction one because I haven't. I recently added the advertising because we were starting to get things. So I'm sure something else will crop up over the years. But if you just can read and just know, you don't have to remember it all. But when something happens, you just think, oh, I remember that could be a problem, and then you can go back and look.
Correct.
But I don't like making up statistics, but I would imagine 8 out of 10 calls I get, the answer would have been in here.
Wow.
And you know that when there are questions about what to do, there's times when agents call with seller or buyer situations that we need to talk through and work out the way. And you know, one of the things that's fantastic.
Oh, you know which one you missed here? Huh? The days.
Oh no, that's not. The days on how to calculate time is the most asked question. Time is the most asked question.
Everything.
But most agents that call actually know the answer, which is refreshing to me. You know, when people call me, they say,
"We just need confirmation from Master Jedi."
I know, but you know, I think it's good when we talk things through and we have a problem. I say, was that what you would have done? And they said, well, it didn't cross my mind. So it's there, and it's just nice to be able to consult with them.
Correct.
So that they have a confidence in their own answer. And I do the same thing. I'll get a situation sometimes, and I think, you know what, I know what I'm going to do, but let me just see what Sally says. Or let me call another broker that I know and just say, what would you do in these circumstances? Because sometimes, you know, when you've been doing something a lot over a long period of time, you think, well, am I actually doing it the right way? Is there a better way of doing it? And I still go to contract classes. If I see a contract class that someone's teaching that I've never seen before, I'll go because I guarantee I'll learn something.
Oh yeah, for sure.
Yeah, guarantee.
I always say that to our agents. Whenever there's a contract class, you need to be in that room.
Yeah, it's fun.
Yeah, it is fun. I mean,
I like it.
It's
my hobby.
I love contracts. Awesome. So there we have it. 18 ways for you not to get into trouble, but these are the ways that you are getting into trouble. Murray is available, guys, so if you need him for anything, just call him or send him an email or text him. Now you know that, you know, he prefers the computer for his eyes' sake.
Yeah, if it's urgent.
But if it's urgent, just call or text.
Yeah, I don't mind a text, but if you've got to send me a document, text me and say, hey, I want you to look at the document.
Yeah,
and
absolutely.
It's a lot easier.
Don't do this alone. You have plenty of support, so let's stay out of real estate jail.
Exactly. No, that's fine.
Thank you for your time.
Thanks. Good.